YouTube. Let me get the gram started. All right, I got it started on the gram. Man, yo, I can't stand no Facebook, yo. Facebook won't let me even put up my show, the link to my show and all that. Like, they blocking me like crazy. I guess they don't want my message out. They don't want me teaching y'all law, man. That shit is crazy. It really don't make no sense because everyone else gets to do it, but why they picking on me? That shit don't make no damn sense. You pick on one person. I see. My thing is, if you do it across the board, then cool. You know what I mean? But don't just do it to me and no one else, man. That ain't right. That ain't right at all. But we got an upcoming seminar on the 31st in New York City, in Harlem. But you want more information, go to jonahbabe.com to check out the information for the up and coming seminar. It's called The Keys to the Republic, where we're going to go all into how you got to be private, how you're going to be private, and make money too. You know what I mean? It don't mean nothing. You ain't making no money. You feel me? I'm about my commerce. I don't know what y'all heard. I'm about commerce, which also remind me, I don't know why people hit me on Instagram, Facebook, my website, and be asking me to do stuff for free. I'm not working on no one's case, no one's anything for free. Check this out. I'm on the radio for free. And I'm teaching classes for free. Stop asking me to be my apprentice and all that shit. If you listen to the show all the time, you are an apprentice. You learning law for free. It costs me to teach you, but it's free for you to listen. See, you have to pay me if you want instant gratification. That means I got to put my energy into it and help you. I got to write shit for you. I got to teach you what to say. That costs. That costs you. But if you go and listen to the shows and go into archives and learn, you can learn it for free because even my templates, I will read the templates on the air. All you have to do is listen to the show, stop it, write it down, start it again, write some more down, and all that. Yo, you can't get something for nothing. All right? So don't ask me to do nothing for free. I even answered y'all's questions on the air for free. You know what I mean? If you can't afford a consultation, then you need to get on the air before 7, put your hand up. That's going to make you be at the top of the list, and I will get to you and answer your questions. If you got mad questions, go into the archives. Most of the time I've already answered those questions. My archives is soundcloud.com, the Jonah Bay archive. The is spelled Thee, Jonah Bay archive. All right. So that's with that, because I really get annoyed, and then they want to attack me and be mad. You ain't supposed to be charging. How the fuck I ain't supposed to be charging? Who rules do you live by? Them ain't my rules. Nobu Drew Ali charged. Y'all had a weekly donation y'all had to do to be a part of the temple, and y'all still do with all the other temples. That's charging. That's charging. Why? Paper ain't free. Computers ain't free. Being on this air, buying time. Like, I got to buy time for Blog Talk Radio. That ain't free. It's kind of expensive, right? All of that ain't free. Y'all really believe I'm going to use my money to, to teach you? No. If you want to learn it, then you have to pay the cost. And the cost is it's going to take you your time. You're going to have to get on the show and listen to them. That's how you'll learn for free. But you want it right away. It don't come that way. It don't come that way. Anyway, so I'm drinking some tea. It's called trumpet tea. And you want to get it from the trumpet tree leaf. And this is what it's used for. It's used for treatment of bronchitis, hypertension, obesity, bacterial infection, respiratory disorder, and diabetes. The leaves are also used in the management of liver conditions, anti-inflammatory activity, management of cardiac conditions and hypertension, kidney conditions, treatments for diabetes mellitus, treatment of asthma, cold, flu, and management of Parkinson's disease. So I know y'all all got one of these ailments. So you want to get yourself some trumpet tree leaf and use it 3 times a day. And even if you don't, get yourself some trumpet tree leaf and use it 3 times a day. It's going to stop any of that from happening to you. All right. And I want tonight's show, I'm going to be talking about Rule 56, summary judgment. You know, everyone is hitting me up with questions about accord and satisfaction and all of that, right? And this goes for accord and satisfaction and any other thing, any other court case. This is why I ask y'all, it's not necessary, but it sure is better if you do the 1, 2, 3 administrative process. Because when you do an administrative process, you can put in your lawsuit and ask for summary judgment. Now, it's Rule 56 of the Federal Rules of Procedures. Let me put it in the chat so y'all can read along with me. All y'all who want to learn, y'all supposed to, and y'all newbies, y'all supposed to pull up everything that I pull up and read with me. That's how you're going to learn. All right. So then it says summary judgment. A motion for summary judgment or partial summary judgment, a party may move the summary judgment identifying each claim or defense, or part of each claim in defense, on which summary judgment is sought. The court shall grant summary judgment if the movant shows that there is no genuine dispute as to any material fact and the movement is entitled to the judgment as a matter of law. The court should state on the record the reasons for granting or denying the motions. Now, I hope you peep the last part. When you put in your motion for summary judgment, if they deny it, you're supposed to say why. You got to put it in writing. You got to put it in the record. You got to cite case law, right? But it says y'all don't have any dispute on the material facts, which means if you wrote them 3 goddamn times, the administrative process, asking them to rebut or anything, and they didn't do it, then y'all are in agreement. Y'all are in agreement, especially if you put in your letter or your affidavit, you plan on suing them. If they don't rebut and answer, you're gonna sue them. So now they didn't answer. So guess what? You sue them and get a summary judgment. See, don't y'all know that's how the IRS do you? The IRS sends you 3 letters saying that you owe money. But you motherfuckers, y'all be ignoring shit. So then when they finally go to the court and get a garnishment on you, And let me keep it real. The IRS does not go to court and put a garnishment on you. All they do is put in a notice of lien, and then they start garnishing you, and they give that to your job, and they just take it out without no court order, which, by the way, is a suit. 241, 242 suit, which is coming. The webinar is coming real soon, right after New York seminar. All right. That's illegal if it didn't go to court. Don't y'all read the Constitution where it says they could not take any of your property without giving you just compensation or due process to take it away? If they didn't go to court and get a summary judgment, guess what? No due process. That is unconstitutional. This is why I'm trying to tell y'all the Constitution is a trust agreement. And you must learn it verbatim so you know when people are trampling on your rights protected by the Constitution. So then you can do a 241, 242 suit and get paid. I don't know about y'all. I like money. I like money. You don't like money? You know, they say money can't make you happy, can't buy happiness, but it damn sure can buy respect from people, even your family members. So let's finish reading summary judgment. B, time to file a motion. Unless a different time is set by local rule or court orders, otherwise, a party may file a motion of summary judgment at any time until 30 days after close of all discovery. So you can put it in any time just before trial. Close of discovery is the trial date. All right. If y'all going to trial, right? Now, also, let me say this for the newbies. Y'all, when y'all using Rule 56, I want you to use everything that 56 is telling you, but don't put Rule 56 of the Federal Rules of Procedure. All you do is use what's written in it and explain what they must do, and that's it. He's Baked Music says, if they don't try to kill you first. Yeah. You know, so many people has done 241, 242 suits. They have done 1983 suits and won. None of them got killed. So, you know, we can't be afraid to use their laws and their trust indenture against them. I mean, keep it real. We are so-called black people. We're Moors, but so-called black people. Y'all got other things to worry about. Like a ignorant nigga, you go outside, he trying to steal your car, your money, or whatever, and kill you. I am not going to be sitting here worried about the so-called powers that be trying to kill me. Fuck all that. I ain't no scary nigga like that. You feel me? Number C, procedures. Supporting factual positions. A party asserting that a fact cannot be or is genuinely disputed must support the assertion by A, citing to particular parts of the material in record, including depositions, documents, electronically stored information, affidavits, declarations, stipulations, including those made for the purpose of motion only, admission, interrogatory answers, and other materials. See, now if you sent them the third-party debt collector letter, for example, those are interrogatories. They don't answer them. That is a reason for you to go to court and ask for summary judgment. If you put in your affidavits and declarations with stipulations, like the stipulation where I say I got a $9 billion lien, and you're going to be charged $9,000 an hour. That's a stipulation. These are all the things that you're referring to where they're supposed to give you summary judgment. All right? 2, objection that a fact is not supported by admissible evidence. Now, y'all know when y'all put in affidavits, or let's say you do what is it? It'll come to me. Your take judicial notice. Your judicial notice. When you put in your judicial notice, you ask for a motion. You put in a motion to be heard. You set the date for that motion to be heard, right? Did y'all know that when y'all put in any motion, you're supposed to be putting in a motion to be heard? So if you're doing this summary judgment, you got to be put in a motion to be heard on the summary judgment. That's when if they deny it, they supposed to support it by law. Cite some laws, all that, and put it on the record. It has to be on the record. They can't just say, yo, we denied you and didn't give you shit. It don't work that way. You have to know what they're supposed to do, and you hold their feet to the fire. You know what I mean? You have to. This is very key. This is very important. A lot of y'all don't know how to maneuver under their rules. And I tell y'all all the time, our arguments are impeccable, but your procedure sucks. So they be using procedures to deny y'all. That's what they do. So you can't do that. You got to know what they supposed to do and call them on it. Be like, nah, B, that ain't the way it works. You know what I mean? Don't y'all know that we really studying to be lawful attorneys or lawyers, whatever you want to call it? I don't like neither one of those words, but you have to know the law, which is the Constitution, and hold their ass to it. So it's very important that y'all get these lessons when I'm teaching them, like this Rule 56. So let me go to the next point. Objections that a fact is not supported by admissible evidence. A party may object that the material cited in support or dispute of a fact cannot be presented in the form that would be admissible in evidence. Now, y'all know we do everything by affidavits, even our motions, and we do it under perjury, right? The threat of perjury. And we also write unsworn declaration, which means that you're swearing to it without the United States, not within, without. Now, if you don't know how to do an unsworn declaration, Google unsworn declaration. I taught it. It's in the archives. I don't have time to go over that and this tonight. Maybe in the future, I will go back over sworn declaration, unsworn declaration law, right? Because a lot of y'all be lazy on y'all studying. So you're not going to worry about that, because if it's in affidavit form, ain't shit they could do about it. Number 3, materials not cited. The court need to consider only cited materials, but it may consider other materials in the record. Now, the cited materials is going to be your Constitution. And they can't deny the Constitution. See, when y'all tell them to take judicial notice of a constitution, what are y'all doing? Y'all are putting the law on the record. You are putting the law on the record. If you don't put a law on the record, guess what? They use any law they want to. And they use at-law laws that will what? Fuck you up. That's what they do. So you have to put the Constitution. I don't give a fuck what case it is. Number one thing is tell them to take judicial notice of the Constitution motion to be heard. And that's another thing. I'm going to have to go over judicial notice again because that's where it explains about the motion to be heard. All right. Number 4, affidavits or declarations. An affidavit or declaration is used to support or oppose a motion and must be made on personal knowledge, set out facts that would be admissible in evidence, and show that the affiant or declarant is competent to testify on the matters. So it just broke down what a declaration is. It just broke down what an affidavit is. And it just told you at the end that you have to do it under a sworn oath. That was the declarant is competent to testify on the matter stated. That means you are a witness. You was there. Now, do y'all know none of these motherfuckers was there? That's Pagliari versus Trinsky. So anything they say or they try to make an affidavit, I object. Now, either sustain it or overrule it, but also put it in writing. And if they don't, I take exception to it. I take exception. You must cite whether you are going to overrule it or not. Y'all got to know that trick. They doing that in court every day and fucking us over. You know what I mean? All right, so let's go to D. When facts are unavailable to the non-movement, if a non-movement shows by affidavit or declaration that specified reasons cannot present facts essential to justify its opposition, the court may, number 1, defer considering the motion or denying it. Number 2, allow time to obtain affidavits and declarations or to take discovery. Or number 3, issue any other appropriate order. See, so you doing the things that I'm telling you to do, you're gonna be okay. They're not supposed to be able to deny your motion. Yeah, I take exception. That means like what the judge do. This is the shit they do in court. You'll say, I object. And he'll say some shit like, we'll come back to that later. That's a novation. We'll come back to that later. That means he did not say sustained or overruled. He got around it. You can't let him do that. You got to call him out on that. Because if the objection don't go in, guess what? No objections. You can't have no what is it called when you have a retrial? Appeal. You can't have no appeal. You didn't object to anything. They ain't got nothing to look at. You see what I'm saying? So it's crucial. I still had quite a bit more to read on this, but all right, if they say denied, that is the same as saying overruled. Now, when they say denied, they can't just say denied. Do you know that? They got to cite the laws and all that to say that. See, the problem is they could say denied, not give you a reason because you don't know they got to give you a reason. And one of the main problems you had, you didn't do a motion to be heard to set up a time where y'all were in court to talk about the denial. See, if he denied you, you did a motion to be heard, and you did a motion to be heard off of a motion that you put in, and you went to that court date, he's going to say, yo, you put in this motion, I denied you, and this is why, and this is da. Procedures. See, like if you didn't set that motion to be heard, then you didn't give them time to actually research it to give you the reasons, right? So they trying to make it seem like, if you didn't put in a motion to be heard, you waived it. Don't waive shit. You can wave at me, but you don't waive your rights. All right. So with that being said, let me open up the call lines because we're gonna fuck around. I'll finish the goddamn show just teaching. All right, I'm going to 774-467. Peace to the God. Peace.
Peace to the guys, Mr. Jonah. Hopefully you had an excellent weekend. Your
I did.
Blessed.
My family ain't even here. Me in London's here, but the girls, they in England.
That's right.
They went on vacation. Yeah, they've been vacationing all summer. God damn, they fucking my pockets up, boy. I don't like all that vacationing like that. And even when I go to New York to do the seminar, they're coming from England to New York to do vacation. But baby girl also got a recital to do on Broadway for her dancing.
That's amazing. You're living a blessed life. Let me tell you, that's a great.
Hey! I'm not living it. She living it. You feel me?
Yeah, no, that's awesome. That's awesome. All right, I will be concise as the time is going down.
Yes.
And I appreciate your time. So I rewatched the Accord and Satisfaction webinar.
Absolutely.
Right. As we speak, I'm producing a third-party debt collector letter, aka a bona fide complaint for AT&T. And I know AT&T is a third-party debt collector too, especially because they're hypothecating like everyone else. But what do I put down as my argument?
Okay, you did the third-party debt collector letter, right?
Yes.
And did you do Accord and Satisfaction?
No, I didn't do that yet because I know that's
then you kind of ahead, aren't you? But if they can't answer your interrogatories, then they're not your creditor. So your beef is you're not a true creditor. It's already written.
It is.
When you said yes, it is what?
No, that I know they're not true creditor.
Okay, so it's already written in your third-party debt collector letter, and you gonna tell them? Did you send them the non-contact contract?
No, I didn't send it out yet. I'm just writing it. I'm typing it up. I need to get it notarized before
You typing it up? Oh, your changes to it. You're typing up. All right.
Yeah.
I thought you said you already sent it to him.
What? Sorry, I didn't catch that.
I thought you said you already sent it to him.
No, sorry, no, I didn't send it. I didn't send anything.
So you ahead of the game. You ahead of the game. You're just trying to see what pitfalls can come. Nah, finish writing it, get it notarized, make it an affidavit, send it to him, registered mail, CEO of the company.
Got you. The only reason
and the person who contacted you.
The only issue I had was I put my name, and instead of yours in other places, but I didn't know what to put as the argument. I didn't know what to actually put.
The argument is in there. Read the document. It's in there. The whole third-party debt collector letter is about a debt collector who is not the creditor trying to collect. That is the argument. Read it. Overstand it.
Right.
Look up some of the laws on it.
All right. All right. The validation part of it. All right. That's right. If that's all I need to say, I thought I need to put something else.
It's no. All you got to do is make it, the so-called third party, you got to put the name of them and your name you got to put in and all that. It's a template. It ain't much to change. But some things in there may not apply to you. Of course, take that out. But the rest of that shit you leave in.
Okay. If that's what I need to put, that's gonna be good enough. I appreciate your time.
All right.
Until we talk again. It was a pleasure.
Peace to the God. It definitely was a pleasure. Someone asked, where do I find a no contract contract? Is it supposed to be with the debt collector template? Obviously, you didn't buy your third-party debt collector letter from me. If someone must have gave it to you. Because yes, it does come with the template. That's one template. So whoever gave it to you gave you half the shit. And this is why y'all ain't supposed to get that from other people. Get it from the source. Don't you know if you getting it from other people, you letting that person bootleg me? Which is kind of fucked up, man. I need my money. I created it. I need my money. Let me see what's going on with the YouTube live. Yo, Chucktronics, registered mail, restricted delivery. You don't want to do restricted delivery. That's why I didn't tell you. I don't be leaving little things out. I take the path of least resistance. If you do restricted delivery, the person who opens up his mails and get it, which is his secretary, won't be able to collect it from the mailman and get it. So therefore, it will never get to him. Some of y'all be too damn smart for your own good. You know what I mean? And that would have messed up your whole procedure. Someone said they got theirs from Gene Keaton. What the fuck Gene Keaton doing selling and giving people my shit that I created? That's crazy, man. I need to talk to Gene about that shit. All right, let me go to the next caller. I'm going to I thought I was on the phone with one person, but look like other people came on. 682-250. Peace to the God. Peace. Did we talk already? Hello?
Nah. What's up, Jonah?
I didn't think we talked. I don't know why the counter's on, but what up, bro?
All right. I had a question for you. I hope I can get that in, but I want to kind of stay on the subject with you about summary judgment.
Yes.
As far as judicial notice goes, can you put in multiple evidence under that one motion?
You could. Like the number one thing you're gonna put in judicial notice is you're gonna put in your constitution, right? But you might have the summary judgment. So you're gonna be like a motion to be heard on summary judgment. And you're just gonna say summary judgment. You know what I mean?
I didn't know you could do that. Like put a motion to be heard on a summary judgment.
You have to, because how they gonna break down if they say no, what's the reason?
Right. So
see, y'all been skipping that process. So you'll be in court and you don't have a real hearing to be heard, right? So don't you know they do it to you all the time, do a motion to be heard. They call it a rule nisi, or they call it a show cause. See, they do it to you, but you ain't doing it to them. You got to hit them with the show cause.
Okay. Because I was reading here in the state, the summary judgment for the state, and it seems like they still give them an opportunity to answer.
Oh, you doing a
You know what I'm
motion
saying?
to
Like,
be heard? They gotta answer just like you would have to answer.
right.
Yeah,
Okay,
that's
I got
good.
you.
But you gotta make sure when
Yeah,
they
'cause
answer, is it in affidavit form? You gonna say what? What you gonna say to them if they put in an affidavit? See?
I guess that's that.
I caught you slipping.
Trinsley package.
Yes, that's it. I object.
Oh, okay.
They have no firsthand knowledge. Matter of fact, if the counselor wants to say anything, I need him to come up here and be sworn into the court since he wants to act like he's a witness.
Right. So let me get it straight. After you do the admin process, you default them out. When you file a case, you could come right in and say summary judgment.
A motion. You do a motion for summary judgment. First, you're going to do your complaint. You got to do your complaint. And then you put in a motion for summary judgment and a motion to be heard. Because now we got to talk about this summary. Here's my proof. I gave them 3 chances to answer me. They didn't answer, so they agree with the material facts. This is why I should have summary judgment.
Got you.
It's very simple. All right, peace, my brother.
Hey, one more question.
Nah.
Real quick.
I only got 5 minutes. Nah. No. I only got 5 minutes.
All right, good. No problem.
All right. So let me try to get through this real quick. Someone sent me a court of satisfaction, and peace to the guy. I did the court of satisfaction process. After I filed my suit in Smalls Claim Court, the finance company was deleted off my credit report as they never existed. However, I was still paying into the court date, so they wouldn't come and get my car. But just 3 weeks ago, someone hit my car for the insurance company totally totaled it out. So now the insurance company is ready to pay out, but I still need the finance company to release the title before I have insurance to pay out. Listen, if they take that money, your remedy is you're going to sue them for unjust enrichments. That money's not theirs. All right? That's your answer. So that's tonight's show. I hope y'all enjoyed it. Once again, we had an upcoming seminar in New York City. It's called The Keys to the Republic. Go to jonahbay.com for more information, the flyer. You can pay at the door. You can pay now. I hope you pay now. So I know how many people are coming. And you know what? I got time for one more caller real quick. We only got 2 minutes. 321-291. Peace to the God. Peace.
Yo, peace to the God. Oh shit, I'm in. Yo, peace to the
God. Nigga, hurry up. I said we only got 2 minutes.
I know we got 2 minutes. It'll scramble my whole brain. If they don't answer your judicial notice, they answered it in court. I read it on the record. I filed it in court. I made a motion to be heard. We went to that date. We had other motions and stuff we was hearing too, but we brought that up. I said the judge didn't really put it on the record as ordered and done. I'm going back to court this week. Would I raise that again?
You have to. Yes. You're going to do a motion of error explaining that he never showed the law why he denied ...
Heard that. That's what's up. Peace to the God, yo.
All right, peace to the God.
Great show. My mom ain't gonna listen to this show, God.
Well, thank you, brother. Thank you. Well, that's we only got 90 seconds, so that's our show for today. I hope y'all enjoyed it, yo. It was packed full of a lot of goodies. But anyway, peace to the gods. I'll see y'all what? Wednesday.
Thank you for using Blog Talk Radio. Goodbye.
YouTube. Y'all was kind of quiet tonight. But I hope y'all enjoyed the information. It was I didn't get everyone to hit me with that thumbs up, man. Y'all gotta start showing me some support with the thumbs up, man. Appreciate that, yo. Anyway, we out. I'll see y'all Wednesday. All right, peace.